that's it. I think we can open it up to questions.
Great. I have a couple questions already in the queue, but if other people have them, go ahead and type them in. We'll try to get to you. The first question is about students who are working on a university or college campus. Do these laws apply to them as student workers?
As student workers, I would say yes. I mean, if they are paid, because it applies to the Illinois law applies to paid part-time workers, so it would apply to them. I mean, like if you're working in the admissions office or something part-time, it would apply to that workplace.
Okay,
Um,
great. And then this may be a different conversation, but so a similar question: does a student who is not an employee of the university, does the university have to provide pumping accommodation for a student?
So for a student who's not an employee, they're not going to be covered by the employment laws, but in terms of federal law, Title IX is the federal law that requires, I mean, that prohibits sex discrimination against students. And so I would say generally under Title IX they have some rights for pumping accommodations, but it's going to be a different set of laws and a different analysis about what they're entitled to.
And I would just add in that there are actually some other Illinois statutory and constitutional rights that could come into play. But again, it depends on, is the university a state university? Is it a private university? And what the exact circumstances are. So those are things that would be hard for us to answer generally in this particular webinar, but there definitely are some rights out there that someone could explore.
That might be a future webinar, huh?
Yeah.
Okay, the next question is, this woman says that her employer does not have any policies in place for accommodating lactating moms, and is there something that HR should be providing in terms of policies? And if they don't have that, is there some recourse around it?
So in terms of having an explicit policy, the Illinois law does require that employers put up a notice, which is just like a little poster informing employees that they have rights under this law. And it also, if there's an employee handbook, there needs to be some notice in the handbook. The law doesn't say that employers have to have, a written, detailed policy about what employees have access to. And so if there is, I mean, if there's no policy, I mean, that, she should talk to HR. She could certainly say, you guys should put together a policy, but, that doesn't mean that she's not entitled. She's whether or not they have a policy, the employer is entitled to everything that we've said here today.
Gotcha. Great. This goes back to when you were talking about good places to pump that are free from intrusion. And this questioner is asking, what does that actually mean? Does it mean that there's no physical entry to the space? Would banging on the door or talking to you through the door be counted as free from intrusion? And are there any recourses if a woman feels like she's not free from intrusion?
Wow. I mean, it's going to depend so much on what the circumstances are. I mean, if, certainly anything where people are actually physically walking into the space or not respecting signs and things like that, that's definitely not free from intrusion. Talking to you through the door.
So I'd like to actually jump in there and just say the law is not clear about it. We know that the law is not clear, but having said that, I would urge anybody who is in the position of trying to initiate this conversation with their employer and keeping in mind that what your role is with a lot of employers is to try to educate them about the benefits to them of doing this, about the legal requirements, and about what your needs are. I would urge you to make clear that yelling through the door is an intrusion. And even if you couldn't file a lawsuit on that, or if you filed the lawsuit you might not win, I'd still urge you to make that clear, to sensitize your employer to that fact, because the reality is it does interfere with your ability to pump efficiently and get back to work.
Yeah, and that might be a situation where bringing in some of the some resources that say you really need to be able to relax, and if you are constantly interrupted in that way, it actually makes it harder for you to produce milk, and you're going to end up needing more breaks. Might be something that an employer would be sympathetic with.
Right. This mom has a question about her baby is with her at work. I believe this mom works in a daycare facility, but I may be wrong. Is she also protected to take breaks to breastfeed her child, not just to pump?
Yeah, absolutely. So the Illinois, in particular, the Illinois law covers any kind of condition relating to pregnancy, lactation, expressing breast milk. It doesn't have to be pumping. It could certainly be, and I mean, in some situations like this one, it's obviously going to be a lot more efficient for her to just nurse her baby directly instead of pumping. So it definitely covers that, and that's definitely a reasonable accommodation to have your baby brought to you, assuming that it's not going to disrupt the employer's operations in some way. Great.
There is a question, somebody is asking about, can I have examples of reasonable accommodations for people like firefighters, teachers, police officers, and midwives and doctors? I would point them to the womenshealth.gov website. They have a lot of great examples. Amy and Lori, do you have any other websites or resources to point people to?
I think the womenshealth.gov website is a good one. I mean, it's as I mentioned, those are not always going to be the gold standard in terms of the absolute best that an employer can do, but it does encompass a lot of different industries and has some kind of creative things that employers have done, and again, and it's really going to, I think, go back to two things. One is really look into what are the ways in which your employer accommodates people who have other temporary needs for accommodation. So disabilities, illness, injury, look at how they treat people who are injured on the job. Sometimes, if they're able to make these accommodations for other people who work at your workplace, then that suggests at least that they can make those accommodations for you. And then the other thing that I would say is it really depends on your employer, and some of the things, going back to firefighters, if you're working a 24-hour shift, you're obviously going to need more than 2 to 3 breaks to express breast milk, and so your needs are going to be different.
So I just want to add on to that. Be creative. I think what Amy said is exactly right. I would also suggest that you be creative about what you're looking at in terms of what the employer allows. So one of the things that we've seen, for example, is an employer that allows employees generally to take a smoke break. And they're allowed to go outside. Maybe that means going down a number of elevators and going out to whatever the designated smoking area is and have a cigarette and stand there for a little while and come back. If they're letting employees do that, that can be used to show that they obviously can make a reasonable accommodation to give you a break to pump under whatever the circumstances are, if you're, in a firehouse or you're in a police station or whatever. So be creative, look broadly at what other policies or de facto policies that the employer already has and use those in your conversation, not to make it a nasty conversation, but just to use as a comparator.
Great. Is there a requirement for how many lactation spaces are necessary for a certain number of employees?
No, and that's really just going to depend on the workplace and how. If the company set it up so that you have to use a lactation station, and they've set it up in a way such that there aren't enough lactation stations for the employees to use, and you're waiting or not able to actually use your breaks to pump, then that's not a reasonable accommodation, and they're not accommodating you. But there's no like ratio or policy that that the law says that they have to have.
Okay. I have one more. I have a couple more questions here. Do you ladies have a couple more minutes?
Sure.
Yeah.
Okay.
If people need to sign off, they can do so and pick it up later.
Yes, great. So it says, what if 50% of the workplace works from home? I asked to work from home 5 days a week for 6 months to continue to breastfeed and was told no because it could make other people who don't work from home want to. Do I have any rights to get my 5 days approved?
Well, so if 50% of the workforce is already working from home, I mean, I have trouble seeing why it would place an undue burden on the employer to let this person work from home. I mean, maybe the employer can come back and then say, you know, well, everybody tries to work from, I mean, unless the employer can really show that there's some reason to think why allowing her to work from home will create some kind of huge cascade effects in their operations that will, you know, cause an undue burden, I would be very skeptical about that.
Yeah, I think it just depends very much on the circumstances. From the facts that we have, it's hard to understand why the employer would think that, but I think we'd want to know more.
Yeah.
And so the conversation with the employer would be, you know, I mean, you know, the fact that you let other people work from home suggests that this is not going to cause an undue hardship for you. Can you explain to me why? And really trying to work with them.
Yep. I know that we'll have a couple of people, we probably don't have very many teachers logging in today because they are teaching, but I know we'll have a couple of follow-up questions around teachers in schools and their ability to pump during the school day. If an administrator says, well, I don't have anybody to cover your classroom while you need to pump, can you talk a little bit about what some options are for classroom teachers?
So the law applies to them as well. They are entitled to reasonable accommodations through the, you know, you'd walk through the analysis that Amy has taken us all through. But one of the things I would encourage from a practical perspective is to really look around at other schools and how they're handling it. Because we were actually just having this conversation right before the webinar about the evolution of these policies and how, you know, I have 3 kids, and when the oldest one was going through, there wasn't a lactation room for the teachers. And by the time the youngest one was going through, there were lactation rooms, they had lactation policies, they had coverage policies, and it may be that there are some progressive schools out there that have actually taken the lead on this, and it would be interesting for somebody who's trying to educate their employer and go back to them on this to say, well, this is how this other school is doing it. It seems like just a very much an education and evolutionary process. But the bottom line is that teachers are employees just like all other employees, and the Illinois Human Rights Act provision relating to pregnancy and pumping applies to them.
Great. Thank you so much. We will share all these resources, both we will share at least the bulk of the presentation on YouTube, so it'll be linked to our blog, and any additional handouts and resources we will have on our blog as well. Thank you, Amy and Lori. We so appreciate all the help you've given us today.
Thanks for having us.
Thank you.
All right.
Bye-bye.
Have a great day. Bye-bye.